A matter of Aspen Creek Estates Limited versus Town of Brookhaven. Mr. Mulholland, good afternoon.
Good afternoon, Your Honor. May it please the Court, Mark Mulholland of Ruskin, Moscow, Faltashek on behalf of Appellant Aspen Creek. I'd like to reserve 2 minutes.
Sure.
The question in this case is whether a town may justify condemnation of private property simply by saying it wants to have farms and nice scenery. My client has 39 acres that are zoned residential as of right. It's not a farm today, hasn't been a farm for almost 5 years, but the town wants to take it and make it a farm, again, like it used to be years ago. And the town says, and mind you, this is not a public use case. This land is not proposed for seizure so that it can be used by the public. It's going to be used privately as a farm, as a private farm.
Is there a public interest, though, in promoting and maintaining agricultural space in certain communities?
It may well be, Your Honor. It may well be. And it could be that seizing land to create a farm could be appropriate. But that's not this case. Because if it were going to be done, and done right, and done constitutionally, then there would have to be a carefully considered plan to show how the use of that farm by a private person would achieve some public purpose.
Well, there is a lot of legislation here. The town of Brookhaven has an Open Space Preservation Act. There's a Clean Water Open Space Bond Act. The Suffolk County Agricultural Preservation Plan, the Suffolk County Agricultural and Farmland Protection Plan, all of these things, and the Suffolk County Farmland Preservation Law, all of these things call for the preservation of the farmland, the open space, and the wildlife habitats to maintain the community character.
There is no question that there's a strong public policy in favor of open space, in favor of clean air, clean water, farm preservation.
Why isn't that enough?
It's not enough because we cannot have a situation where simply by chanting some talismans, by throwing out some words, farmland, scenic vistas, that passes constitutional muster.
Yeah,
and that's all we have in this case.
But the words, there are a lot of words, but they're in legislation, and a lot of pieces of legislation have been passed over a number of years.
Clean air is in a lot of legislation, too.
Well, this is specific, though, to Suffolk County.
Well, let's have a town...
Well, I'm fencing with you. I guess your answer is that's just not adequate.
It's certainly not adequate.
What would be? What would they have to do?
Well, they need to show how this farm is going to achieve a public purpose. That's what Kelo instructs us.
I thought there was a plan that they wanted 112 acres.
The plan is very interesting.
And they set aside over $8 million, right?
Let's talk about the MFPA, the Manorville Farm Protection Area. It's not really a plan, it's a map. And it's not really a map, it's a photograph. It's a nice photograph taken in 1993 with some white lines drawn around it. And it's very interesting because it creates a completely circular argument. The town said in 1993 that these are the 500 or so, some odd acres. It's not very precise, mind you, this aerial photograph. There are some 500 acres that we think ought to be condemned someday to preserve farmland.
Well, they have acquired some of it, have they
not?
Some,
about 117 acres. And we're concerned about the selective manner in which over the last 15 or so years they've discreetly chosen where and when to actually go in and condemn a particular piece or acquire a particular piece of these 500 acres. But interestingly, they said in '93 that these are the lands that ought to be condemned. And now today they justify condemning my client's land by saying, well, it's on the map. It's on the map of the lands that we said has to be condemned. It's completely circular. There's no plan. And there has to be a plan. Who's going to run this farm? Brookhaven's not a farmer.
And how do you define a plan? There has to be a legislative resolution that somehow gives a meets and bounds boundary of the area that they're looking at, or?
It's not clear from the constitutional cases I've looked at that the plan has to take on any particular format. But there's got to be something. Right now, questions abound. Who's going to farm this land? Brookhaven's not a farmer. What crops are they going to grow? Is it going to be a dairy farm? Are they going to have animals? What kind of pesticides are they going to use?
And they can't wait and see what property goes up for sale and then attempt to buy that?
Well, without knowing...
Because there certainly were offers here made, right, to your client?
There were offers, absolutely.
That he apparently found inadequate.
Inadequate, yes, Your Honor, in the condemnation process. We need to know how this particular farm is going to achieve a public purpose. That's all that the Constitution requires.
Suppose your client had chosen to sell, and that this had been a voluntary transaction. Would it have been within the power of the town board to buy the land?
Absolutely.
So to that extent, it is a public purpose, then?
Well, but the public purpose requirements for condemnation are very different than the public purpose requirements that must back up an acquisition done voluntarily.
What says that?
Well, we're dealing here with Fifth Amendment jurisprudence that's been developed for the last 100 years plus.
Well, like Kelo, for example, is what you're saying.
Certainly, Kelo is a mainstay in that pantheon of Fifth Amendment cases.
So, but you read Kelo as saying that the public purpose required for condemnation is more than the very vague public purpose that that's required for a town to do anything.
Well, we do. We think it's not enough to say words. There's the Clean Air Act.
No, before you go back there, I want to follow up with what Judge Smith just said. If your complaint is we don't know who's going to farm it and we don't know what kind of fertilizer they're going to use, if they try to buy it from you for a public purpose and pay you cash, is your purchase contingent upon them telling you who the farmer is and what kind of fertilizer he's going to use?
Absolutely not.
Well, so what you're saying is that not you then, but the person down the road who doesn't like the fact that his tax money is being used to give you several $1 million for this land, he comes in and says they're buying this saying it's for farmland, but we don't know who's going to farm it and we don't know what kind of fertilizer they're going to use. Do we give him the same standing we give you and say, you know, he's got a right to do this because apparently there's no plan?
I don't believe so. I'm in a unique position because I'm protected by the Fifth Amendment, and I don't believe that taxpayer bringing a waste of public money action under the tax code.
Well, that's right, and that's why it seems to me your argument, to the extent that you're saying we don't know who the farmer is and what the fertilizer is, and saying, you know, everybody wants clean air, is really addressing what you say your issue is, which is that they're taking your land without due process.
Well, see, what happens is if there's not a plan to look at, then how can we understand the bona fides of the public use claim?
I understand that, but that's why I followed up with Judge Smith. You're saying that the bona fides change depending on whether or not you take cash or whether it gets condemned. That somehow the standard's different in terms of due process and the general public.
It's certainly different. The Fifth Amendment makes it so. And we have to have a situation where we can challenge the claim. It can't be, I'll go back to clean air. Who could be against clean air? Well, what if the next chant, instead of farmland and scenic vistas, what if the next chant is clean air? So we're going to condemn those businesses that have smokestacks. Don't need a plan. Who could be against clean air? What about quiet community? Who could be against that? Let's condemn the businesses that exceed a certain noise decibel.
Well,
Don't need a plan.
I think you'd have to concede that what's involved here is a little bit more specific than a general desire for clean air.
What we see is a disturbing pull-up-the-ladder strategy. The town elders are saying we're quite content to stand on our porches and look out from our Victorians and see scenic vistas, rolling farmland, pastoral landscapes. We like what we see, thank you very much. We're pulling up the ladder behind us. No one else can join the club.
Well, if they're willing to pay market value for the privilege of seeing nothing when they look off their porches, aren't they entitled to do that? It's not that they, you know, they aren't, it's not, this isn't zoning. They aren't forbidding people from exploiting their property. They're just saying, well, we're going to give you the fair value of your property instead of the property.
It may well be that they can do it, but show us a carefully considered plan how this is going to help the public. Their resolution says it's going to help the economy. What does that mean? I submit it's a buzzword, and it means housing values will go up. Did they do a study to show that? Do people pay more when they're buying next to pastoral farmland? Who knows? It's just an inference.
Let me ask you a different question from you argue under both the federal and state constitutions, I guess.
That's correct.
Are you arguing that the state constitution is different, that it gives more protection than the federal?
Well, this court can certainly make that determination.
So you say we don't have to follow Kelo?
That's right. Kelo, in fact, Justice Stevens said in Kelo that the state courts around the country should create their own jurisprudence and determine how they want to respond to these development takings. And there are only three types of takings. There's a public use taking, which this is not. There are the common carrier takings, the utilities and the energy providers, which this is not, and the rest are private use takings.
What would be the basis for us to depart from the federal standard in interpreting the state constitution?
Well, I responded to the Justice's question as I did, but I wasn't necessarily saying, I'm not saying that there has to be a departure. You could determine that for purposes of New York's Constitution, this is what we will require. I believe Kelo requires this. I believe Kelo requires a carefully considered plan to back up any claim that a private use will achieve a public purpose. It's that simple.
If this had been a working farm, would that change the equation here?
Well, it does certainly affect the SECRA analysis. It does not necessarily affect the condemnation public use issue, which we've been focusing on so far. And I could make a few comments as my time's about to expire about SECRA. We think the SECRA side of this just reeks of bad faith. Of course, under SECRA, they were supposed to take a hard look and come to a reasoned determination that this would or would not have a negative impact on the environment.
But how much impact can it have they're essentially leaving the land the way it is, aren't they?
It has been for centuries.
They are not leaving it as it is. It is now, presently, and has for 5 years, been returning to the Pine Barrens compatible growth state that it was over 100 years ago. They're talking about ramping it back up as a modern-day farm. Again, we don't know what they're really going to do. We don't know about the irrigation system, the pesticides. Are they going to use the hard stuff or the organic stuff? There's a school next door. They never did a SECRA analysis of how pesticides will affect that school. This should have been a Type 1 action. It should have been referred to the Pine Barrens Committee because it is in and contiguous to a compatible growth area within the central Pine Barrens region. And on Long Island, the Pine Barrens...
Did the school district object to the unlisted status?
It did not. Not to my knowledge, no. And again, when Tony Kaywood, the owner of Aspen Creek, applied for his development rights to develop his 39 acres, the town rejected him on the ground that it was in a compatible growth area or contiguous to a compatible growth area and had to be referred to the Pine Barrens Committee. But when the town filled out its own SECRA form, they left not applicable. In fact, the form is strewn with not applicables and just incomplete sections.
But the area had been a farm for a long time before it reverted to the Pine Barrens. Wasn't it reasonable for the town to think, you know, it's not going to have a disastrous impact on the environment if it becomes a farm again? With
all due respect, not reasonable at all. It is not reasonable to infer that pesticides and irrigation are good over the Long Island watershed. The Pine Barrens, they are the sentinel of the aquifer.
Is there any evidence that pesticides or irrigation were contemplated, or are you just saying that's inherent in farming?
We don't know. There's no plan. And that's all we're asking this court to do is send them back to the drawing board. We're not saying they can't have a farm and that a farm cannot achieve a public purpose, but they haven't shown it to be so.
If there's no plan, you can't do an environmental impact statement, can you?
No. There's not much we can do except ask this court to send them back to the drawing board. And
You have your 2 minutes, Mr. Mulholland.
Thank you.